Good morning, everybody, and thank you for joining our webinar this morning. My name is Claire Lord, and I'm the head of the Corporate Governance and Compliance team at Mason Hayes & Curran. I am joined by Nick Metcalfe, who is a partner on the team. Tomorrow will be 4 weeks since our Taoiseach announced that the schools were to close. On Friday, it will be 2 weeks since we were asked to adhere to heightened restrictions on movement. All of this has presented much uncertainty for businesses and also countless challenges for all of us, as we have switched to working from home and in many cases trying to operate entirely virtually. What we would like to do this morning is to talk about what is very best practice for directors of a company during a period of uncertainty. And also to give you some practical guidance on ways of keeping the show on the road in terms of having meetings, meeting compliance deadlines, and signing documents. We expect our briefing to run for about 30 minutes. We will then have plenty of time for your questions. If you have a question at any time, please type it in the Q&A tab that you will find, I think, at the bottom of your screen, and we will then run through them at the end of the meeting. So now, Nick, first question. I am a director of an Irish company. The business of the company, like most businesses at the moment, is experiencing much economic uncertainty as a result of the COVID-19 pandemic. I am aware that I continue to owe duties. Could you remind me of these?
Certainly, yeah, and the main statutory duties of the main duties which a director owes to the company, what are known as the fiduciary duties, are set out in the Companies Act, and I'll refer to them as the statutory duties as we go on. And if you could just flip the next slide on, please, those duties are listed there, and they are underpinned really by the first duty, which is to act in good faith in what the director reasonably believes to be the interests of the company, and that underpins the rest of the duties which you'll see there. I would like to note at this point that the final duty listed there, which is the duty to have regard to the interests of a company's members, that is a statutory duty, along with, which isn't listed here, the obligation on a director to have regard to the interests of the company's employees from time to time. And there are other circumstances, and we will come on to this, where the directors must have regard to the interests of other stakeholders in the company.
And on that point, Nick, and particularly given the economic uncertainty and its potential impact on companies, are there any duties that directors need to be paying particular attention to at the moment?
Yes, I mean, certainly the directors need to have regard to all of their duties, not only those listed, but the obligations to ensure that the company complies with the terms of the Companies Act. But one in particular, which is not a statutory duty, but which is still retained in the common law, is the duty in certain circumstances, those circumstances being where the company is either insolvent or where the directors are aware that the company is likely to become insolvent, to have regard to the interest of the creditors of the company. So I mentioned before in the context of the statutory duties that there is an obligation to have regard to the interest of the company's members and also of its employees. But this duty to have regard to the interest of creditors kicks in, as I said, where the company is in financial difficulties, and can be perceived really as a duty to preserve the assets of the company in order that those assets can be used to discharge its liabilities.
Thanks, Nick. And obviously, we're all aware of the possibility of both civil and criminal liability where a director breaches their duties. So could you tell us a little more about this, particularly where a company is or shortly might be facing trading difficulties?
Absolutely. I mean, as a general concept, if a director were to breach any of his or her statutory duties, then he or she could expect to be sued by the company for damages or for to account for any profit that they'd made in breach of their duty. Similarly, if the company fails to comply with any of its obligations under the Companies Act, which are listed, some of which are listed on the slide now on display, and if the director in question was shown to have either authorised or permitted that breach, then both the company and the director could face criminal sanction. However, specifically in the circumstances we were just discussing, where the company may be in financial difficulties, where the interests of the creditors now come into play, there are certain provisions of the Companies Act which is worth going into in a bit of detail. to understand where increased risk of liability may fall on the directors. And the chief one to consider is the concept of reckless and fraudulent trading. And so the Companies Act provides that where the directors of a company allow that company to carry on business, which having regard to the directors' experience, skill, and knowledge, the directors should have known would cause, or anticipated would have caused loss to a creditor, or where the directors allow a company to contract for a debt which the directors did not honestly believe the company would be able to pay as it fell due, then the directors in an insolvency may be found liable to, or may be found to have committed reckless trading. And if they did any of that with the intent to defraud the creditor, that could be then classed as fraudulent trading. And where that comes into play, the directors can be found to be liable without limit for the debts and obligations of their company, and where if fraudulent trading is proven to have committed a criminal offence as well, in addition to the more general penalties which can be imposed on, such as restrictions or disqualification. And so it's important to note in circumstances where directors anticipate that their companies may be approaching insolvency, that they are aware of these particular requirements and restrictions on them, and they take professional advice around where they are and what they need to do with their company. And in that context as well, although it doesn't necessarily fall on the directors themselves, it's important for directors to be aware of what are called in the Companies Act preferences, whereby the directors may be tempted to have the company make a preferential payment to one creditor or to a class of creditor in preference to the other creditors. If that is done and the company enters insolvency within 6 months of the preference having been made, the recipient can be treated as being effectively a surety for the debt that's been repaid to them, so that they could be required to repay that to the company. And that period of 6 months is extended to 2 years, where the recipient is connected either to the company or to a director of the company. So directors need to be aware of that, and maybe to not give into temptation to pay any debts which the company may owe to them.
Thank you, Nick. And I mean, against this backdrop of liability, and considering the common law duty to the interest of directors, or creditors, apologies, particularly at a time of heightened economic crisis and uncertainty, what immediate steps would you recommend that the board of a company should take in order to assess and manage the risk posed by COVID-19?
Well, the principal thing that directors should be doing is that they should be meeting together to discuss and to assess, firstly, the financial position of the company, and secondly, and linked to that, what risks the company may be facing generally and specifically within the circumstances in which we find ourselves. It's an ongoing obligation of the company, of the directors, in their role as managers of the company, to meet, to take decisions, to have a very thorough understanding of the company's financial situation and to assess risk in any event. And in the current circumstances, that's particularly heightened. And what the directors might want to do at these meetings is to consider the cash flow position of the company, as well as its position generally, to consider where its suppliers might be, where its customers may be, whether the company is eligible for any government assistance, and from that, whether the policies to mitigate and manage risk which the company has in place are sufficient, whether they need to be updated, whether new policies need to be put in place, and where any policy is updated or a new policy established. The directors should be careful that policy, the updated policy, is properly communicated to the company's employees, so that they can they are aware of what the company's new policy is, and maybe even if the risk is considered particularly high, to establish a committee dedicated to the current circumstances, on which one or more directors and other outsiders may sit in order to report back to the board. And throughout all of that, it is not inappropriate for directors, if they think it necessary, to ask advisors of the company to join board meetings to advise the directors, provide information that they may not otherwise have, and to provide some guidance.
As we're also so very much aware, the board minutes are always important for directors, and obviously there's a legal requirement for certain information to be recorded in board minutes. Again, at a time like this, particularly given that directors are doing what they can to manage the risk being presented to the company in terms of its solvency and its ability to continue to trade. Anything in particular that should go into the board minutes? Is there anything in particular that should go in that directors should be aware of or thinking about?
Yeah, as well as being a legal requirement, as people will be able to see from the slide currently in view, the minutes of a meeting of directors are the best evidence of what the directors have at any given time discussed, what they have considered, what factors they have and information they have used in order to reach the decisions they made, and how and when and why they made those decisions. And so a full minute recording all of that, recording who may have been in the meeting, both directors and others, is essential in these circumstances, because at the risk of being overly apocalyptic, in these circumstances, unfortunately, many companies are going to experience financial difficulties. Some companies are not going to survive this. And in any insolvency situation, certainly most insolvency situations, the conduct of the directors is going to be looked at the very least. And so it is important for the directors to have a robust set of minutes setting out everything I've just described in order to assist any investigation or scrutiny of what they had done.
We've already had quite a lot of talk about board minutes and board meetings and the importance of them. And certainly a lot of the questions we're getting at the moment in practice is about how we can continue to do that. So obviously we need to be having board meetings, but we've been told to avoid in-person meetings and behave in a manner where we're socially distancing ourselves from people. So how should directors deal with this? Can board meetings be held virtually?
In almost every situation, yes, they can. The directors are given wide discretion by the Companies Act to manage their own affairs, and specifically there is a power in the Act for directors to hold meetings by some form of distance communication, usually over the telephone, but there's by Zoom meeting, by Skype, by whatever. And the Act provides that any director participating in such a manner is deemed to be physically present at the meeting. Now, those provisions are what are known in the Act as optional provisions, which means that if the company's constitution says otherwise, then that provision does not apply to the company. So it is important for directors to check their constitutions.
Thanks, Nick. So a board is holding its meetings virtually. Where is the actual location of that meeting considered to be?
The meeting under the Act is deemed to be either where the largest group of directors is assembled, but in the days of self-isolation, there may not be a large group, it may be one person per location. So failing that, where the chairperson is, and failing that, if, for instance, this particular board does not have a regular chair, or if circumstances have dictated this meeting does not have a chairperson, where the meeting decides that would be. But to some extent, that's going to be a matter of practice.
And I guess we talk about practice and behaviours, and as a lot of directors of global multinationals that have established themselves in Ireland will be aware, where they consider themselves to be tax resident here, and obviously that'll be an important aspect or an important thing for the board to be aware of. There is the importance of making decisions in Ireland by those directors, and also by directors that are physically in Ireland. So how might holding a virtual board meeting impact on this type of behaviour? Yeah,
as you say, it is important to maintain a company's tax residency in Ireland, that it is seen to be controlled and managed in Ireland, and one factor in showing that is that the board decisions are taken in Ireland. And so standard advice is for a company, a board of directors of a company, to hold a meeting with the majority of directors physically present in the jurisdiction. Now, for reasons which are obvious, that might not always be possible. and we've discussed where the location of a meeting might be deemed to be. So this is to some extent a matter of tax advice, and tax advice for the jurisdiction where the largest number of directors may be, not necessarily Ireland. But it is instructive that Irish Revenue has issued guidance, I believe, which states that where a person who would ordinarily or may otherwise have been in the state cannot physically travel because of the current restrictions, Revenue may take that into account in reaching a decision around areas of this nature.
And any advice for the minutes? Would it be important for the minutes to record that fact?
Yeah, absolutely. That's a very good point. That where it is not possible for directors who otherwise would have been in the jurisdiction to be there because of the current restrictions, it's important for the minutes to state that those restrictions were in place. Those restrictions had this effect, and for that reason, and implicitly, I suppose, for that reason alone, the meeting is being held with the directors where they are. That which feeds back into what we were saying before about minutes being evidence of directors' processes and procedures.
We all know there's other ways for directors to make formal decisions, but I think that's a good thing to remind everybody of. So what other ways can directors record the formal decisions that they make?
Well, primarily by way of written resolution. Now, doing that doesn't necessarily solve any tax considerations there may be. And the resolution has to be unanimous, whereas a board meeting could be held with only the quorum present if necessary. A written resolution will require all of the board to have their input by signing or at least consenting to a resolution. Now, those resolutions can be passed in counterpart, which makes that easy. But from a more procedural perspective, whereas we have discussed earlier, it is advisable for board meetings to set out a record of the deliberations made by the directors, what they considered, what they decided. There is less scope for that being possible with written resolutions, so there should be some kind of maybe process beforehand where the directors raise questions, where they deliberate, maybe by email, maybe by phone. But in answer to your question, it is possible for directors to take their decisions by written resolution without need to hold a meeting. It just might not be necessarily ideal in the circumstances.
So we've had quite a lot of talk about directors' meetings. Would I be right in saying that holding shareholders' meetings virtually presents a different set of challenges?
It does, because certainly the AGM, the annual general meeting of a company, is designed historically to be the forum whereby members raise questions of the board of directors. The procedures in the Act and in companies' constitutions governing members' meetings are a lot more strictly laid out. Directors, as I said, have quite a wide discretion as to how they manage their proceedings. And general meetings are set up, if they're going to happen, with the idea that members will come along and be physically present. Now, the Companies Act does provide that a company may hold any general meeting, so annual or extraordinary, in 2 or more venues in or outside the state. And it's probably the case that provision is there in order to facilitate meetings to be held, let's say, where an Irish company had a large number of members who resident in, let's say, the UK. So the idea, I think, would be that there would be a physical venue established in Dublin, where some members and maybe the board would be, and also another venue, a hotel in London, where the UK-based members could attend, and there would be technological means whereby the members could participate no matter which venue they were in. So participate in this context means the ability to participate fully in the meeting, to vote, to certainly to hear and be heard, and probably to see and be seen. Now, that obviously doesn't lend itself to the current circumstances, but it may be possible, with careful consideration, for a meeting to be held with one physical location at which maybe the chair could be present, with other members joining by means of distance communication, as we all are now on this webinar. Now, it is fair to say this is not, as far as I'm aware, a particularly tried and tested method, and should only be done in extremis where a general meeting absolutely has to be held. People cannot gather to meet. And with very careful consideration of the provisions of the Act, the provisions of the company's constitution and what the notice would look like, and really with the buy-in of all the members concerned.
What if I've already given a notice for a general meeting and now find that the company's in a position where it shouldn't be having a large gathering at a venue, or can't have a large gathering at a particular venue?
So the options available for the company in those circumstances are either to postpone the meeting if the company's constitution allows that to happen, which, to be honest, not many do. Or secondly, the meeting could be held maybe if the chair, say, was able to get to the place where the meeting was convened for. The chair could turn up and adjourn the meeting, either by the votes in the room, or more likely because there was just no quorum there, so the meeting would have to be rolled over anyway. Or thirdly, and this would require member buy-in and isn't necessarily ideal, the meeting could go ahead, but with all members encouraged to appoint the chair as their proxy, enabling the chair to effectively hold a one-person meeting, at which he or she could exercise all of the members' votes as instructed under the proxies. That's not ideal, as I said, because it does kind of discount the members' ability to participate in the meeting. They're not really present to raise questions. They're not present to raise any issues they may have with how they feel that the company has been operated. And so if that is going to happen, again, it would require member buy-in. And maybe a process could be set up prior to the meeting happening whereby members could be encouraged to raise questions, to raise issues, and those could be answered in correspondence.
And there's a certain business that a company has to have at its AGM annually, and obviously there's other decisions that members need to take from time to time. It's really not ideal to have to try and convene a general meeting and be confident that the correct processes have been followed. What are the alternatives?
The alternative, certainly where the company in question is a private company limited by shares, the LTD as we call them by shorthand, that company, regardless of the number of shareholders it has, can, again, with unanimous shareholder consent, can deal with the business which would otherwise have been dealt with at the AGM, the routine business which the company is required to deal with annually, by way of written annual resolution. And that is also the case for all other types of company, the designated activity company, the company limited by guarantee, the unlimited company, etc., where that company only has one member. Sole member companies can deal with the AGM business by way of written resolution, as you might imagine.
So staying somewhat, well, actually, onto more practical matters. I mean, obviously, board meetings and general meetings are extremely important. But we look at day-to-day aspects. A company is continuing to do business. It's continuing to contract. Documents need to be signed. And in this country, the practice tends to be that documents are printed, signed, and exchanged in that manner. We're without a lot of equipment we usually have, like printers. And we're certainly getting a lot of questions from client companies that need to sign documents as to how best to do that. Are electronic signatures acceptable in Ireland?
Generally speaking, yes. Now, the underpinning EU law is fairly clear that certain contracts can be signed using electronic signatures, either by way of what's called a simple electronic signature, which would be the typed somebody typing their name in a document, or maybe signing a hard copy and scanning that, to advanced signatures, whereby software is used so that the signatory can be identified by a marker on their signature, or qualified, which is a type of advanced signature where a trusted third party gives a qualifying certificate to independently verify that the person claiming to have signed the document has signed. Irish law is a little bit more vague, and it tends to be the case that only simple contracts, resolutions and minutes are signed by way of electronic signature, and there are certain types of documents which actually can't be signed electronically.
Deeds, I know, are one of those documents. I mean, for an Irish company to properly execute a deed, it must affix its common seal. What do we do in that circumstance?
So, yeah, you are correct that there is no provision for documents to be sealed electronically, and it's not advisable for any document to which the seal is physically affixed to then be signed electronically. And in addition, just to kind of complete the set, it's not possible to sign wills or affidavits or declarations which are sworn, or any document which would probably be a deed anyway, either creating or disposing of or acquiring an interest in real estate. None of those can be signed electronically. But if a company does have to execute a deed, it is possible for that to be done without the seal being employed. And what the company would do is appoint an attorney, and that can be done by a company underhand, so by electronic signature. And the power of attorney would then empower the attorney to execute deeds on behalf of the company. Now, by way of risk management and just the usual way that directors protect themselves from delegating authority, you'd probably want the power of attorney to be quite carefully drawn and to be quite clear on what the attorney's authority is. But provided that authority is there, the attorney can then individually sign a deed on behalf of the company without using a seal, and that signature would need to be witnessed, so that there is an issue there. But certainly the company in question could execute a deed without that company seal being applied to it.
Okay. It's a helpful thing to know at the moment when directors are in different places and the seal is usually at the registered office of the company, which is closed. So staying on the more practical aspects, we've spoken about a number of different things. Obviously, we've spoken about keeping the show on the road. We've spoken about the particular considerations directors need to have, particularly having regard to the interest of the creditors of the company. Obviously, the continuing financial reporting obligations of a company continue during a crisis. What additional disclosures might a company have to include in its statutory financial statements if it was presently at a point in time that it was finalising them for presentation to the members?
Yeah, I mean, first up, I guess this is primarily a question for a company's auditors to assist them with it, and directors should, in any event, but maybe in particular now, have a clear line of communication open with their auditors or their accountants. But just by way of illustration, the Companies Act requires certain disclosures be made in any circumstances, and among those are that a director's report must contain particulars of any important event which affects a company since its financial year end. There needs to be a description of the principal risks and uncertainties facing a company. There would need to be a note on the exposure of the company to any price or credit or liquidity or cash flow risks, albeit in the context of financial instruments, and any likely future developments for the company. So whether and how those are affected by the current circumstances in which we find ourselves will depend on the size of the company, on the market in which it operates, the timing of its financial year, and so on. And again, it is something which the directors need to be aware of, but which they need really to raise with their auditors and have a kind of a full discussion about how the current pandemic restrictions may affect the content of their financial statements.
Okay, thank you, Nick. The final point we might just look at before we move on to taking some questions from our attendees. The CRO, what's happening there at the moment?
So the situation has been fairly fluid over the last couple of weeks, and it is advisable for everybody, directors, whomever, who has dealings with the CRO, to regularly visit the CRO's website just to keep abreast of the latest developments. But where we are currently is that the CRO is closed, but it is accepting submissions by post and by DX. It is not accepting submissions by courier or by hand delivery. There are some kind of exceptions around this. Now, any form delivered by post will be stamped on the day of receipt and will be treated as having been received on that date, no matter when it finally becomes to be processed. And annual returns received by CRO in the period, I believe, from 18th of March to the 30th of June, provided they are received by the 30th of June, will be treated as having been filed on time. And of course, the annual return, like other forms such as the B10 around directors' changes, is a part electronic, part physical filing, so that the electronic filing will also need to be made as well. Certain forms carry quite important deadlines, in particular where a company has used a summary approval procedure to approve, say, financial assistance for the acquisition of its own shares or a capital reduction. The directors' declarations given under the SAP procedure have to be filed at CRO within 21 days of the restricted activity in question having occurred. And the CRO has set up a website, an email address, and that address is available on its website, where SAPs can be filed, SAP summary approval procedure documents can be filed in order to make sure those deadlines are met.
Okay, thank you, Nick. We've quite a few questions from the audience. Thank you. It's great to see such engagement. So we might start taking those now. As we're answering them live, I think the question will appear on your screen, and we'll talk through them. So the first question I'd like to take is actually on the point of AGM. So we're being asked in a couple of different questions. Are there likely to be sanctions on companies or directors where the annual general meeting of a company is held more than 15 months after the last meeting due to the current circumstances? Is that something you'd like to take, Nick? I'm happy to answer it either.
I'm happy to. I mean, maybe we can both input to that. But the failure of a company to hold an annual general meeting within 15 months of the prior one is not a criminal offence. So it is an obligation. It is a serious obligation, but it is something which would be prosecuted, if you like, by the aggrieved members themselves, who may complain to the Office of the Director of Corporate Enforcement. If that happens in these circumstances, I mean, I don't know, and it is not possible to say with any certainty, but some leeway may be given to the directors not convening an AGM within the statutory time periods, given the prohibition on people meeting, and given, as we've discussed earlier on in this presentation, the uncertainty about how a meeting can be held other than with people physically present or by proxy.
Thanks, Nick. I mean, it's not particularly relevant to that question. I know the CRO has indicated that it won't be taking enforcement action if the reason somebody could not comply with the compliance requirement was due to the present crisis. They're not the ones who have the power in this instance, but again, one would hope that the regulator will be pragmatic, where a company had done what it could and it, out of prudence, decided to postpone until such time as it would be safe to hold the general meeting. There's a related question: if there is any indication from legislature that virtual AGMs could be facilitated and valid if, should the PH controls continue, a physical meeting can't take place before the deadlines a body corporate is held to by statute or its constitution. I think in relation to that question, and Nick, I welcome your view as well. So there isn't anything in legislation presently that states that the company can defer its AGM or hold it virtually, arising out of the circumstances. I guess, as Nick would have outlined, it's not altogether impossible for a company to have a virtual AGM, but it isn't certain, and there's certainly procedural elements that could pose issues if there's a large membership, or if there's any issue with the technology that's employed. We have a question here. It actually relates to the minutes of a board meeting. So if all directors are dialing in by way of telephone, what would be the address that should be noted in the minutes? Should it be the registered address or the chairperson's home address? Is that one you want to take, Nick?
Yeah, I will do. Going back to what we were talking about earlier, the Companies Act provides that where the directors are not congregated with a large number of them in one place, which would be the case where they were all dialing in individually from presumably their homes, then the location of the meeting is taken to be the location of the chair. So if an address was going to be put in the meeting, and it should be for the reason we discussed around tax residency and so forth, then that should be the chairman's address, because, as I say, the Act deems the location of the meeting to be where the chairperson is in those circumstances.
Thanks, Nick. We're staying on the theme of board meetings and board decisions, and we have a number of questions here in relation to companies that are going to avail of the temporary wage subsidy scheme. And the questions being asked are: should this be a decision of the board? And while it's not a requirement of the legislation or the revenue guidance, is this a decision that should be made by the board by board resolution? There's also questions relating to the manner in which this could be recorded, and that's certainly a question I'm happy to answer. It isn't something that's specified in the legislation or the guidance, but it is a very fundamental decision for a company to take, and it goes to assisting the company with its solvency position during this time. There's also quite extreme penalties for a company that availed of the scheme that was not otherwise eligible, and it's also a self-assessment scheme, so it's for the company to decide if it is eligible, and there will be audits subsequently by revenue once I guess time permits. So with all of that in mind, our advice is yes, this should be a decision of the board, and this should be a decision of the board that is carefully minuted with reference to backup information as to how the board satisfied itself, obviously relying on guidance from executives that it was eligible to apply. Again, all of this will provide assistance to defend a company's position if their eligibility is subsequently challenged, that it prudently assessed the terms of the scheme and the revenue guidance to understand if it was eligible. So yes, our advice would be that it should be a decision of the board, and the basis on which the decision was made should be carefully minuted. So I might just move on to another question. We do have a question about filing summary approval procedure documents. I think you might have referred to that, Nick, but you might just remind us of what's permitted in terms of filing them with the CRO and the importance, obviously, of delivering them to the CRO.
Yeah, so the summary approval procedure requires a few steps to be taken in it. The directors, all or a majority of the directors, have to hold a meeting. The written resolution procedure isn't available here, at which they make a declaration as to the solvency of the company. And the declaration may vary depending on which restricted activity is being undertaken, but the declaration of solvency is always there. And then the shareholders of the company pass a resolution to approve the restricted activity, whatever it may be. And depending on the restricted activity, the company's auditors may also need to give an opinion on the director's declaration. And then, as we mentioned earlier on, the declaration and the resolution need to be filed at CRO, and the declaration needs to be in within 21 days of the date of the restricted activity, or it will be void. So this is a deadline with serious consequences. Now, as far as the full procedure goes, as we've discussed, it is possible for the directors to hold a meeting virtually or in almost every occasion. The declaration can be signed in counterpart, so that's fine. And the shareholders can pass the resolution they need to pass by written resolution without the need to hold a meeting. So as far as the process goes, then there will be some logistical issues to consider, such as collating the documentation together, posting it to an address where it can be accessed, and so on. But it is possible for the procedure still to be followed. And then the filing, as I mentioned, CRO have made an exception because of the deadline and because of the gravity of the consequences of missing the deadline, whereby the filings can be made to a dedicated email address. And as I said, the email address is available, I believe, on the CRO's website. We haven't, just because I personally haven't been involved in the filing of any SAP documents through that address since it was opened. But I understand that it is being used, and I don't think there are any difficulties with it, although I don't know from personal experience.
Thanks, Nick. I have a specific question here about a location of how a meeting might be located. So the question is: we're a financial services company. Our chairman is based in the US, as are two of our other directors. The remaining 3 directors are based in Ireland. For the meeting to be deemed to have taken place in Ireland, should one of the Irish-based directors take over as chair for the upcoming board meeting?
Yeah, I mean, I'll take that if you like. Yes. Now, this can be varied, but the default position is that the directors get to choose who their chairperson is from time to time, or even from meeting to meeting. And I think it would be appropriate, given the circumstances here, and provided that was fine internally, and that whatever policies and procedures that the company may have internally were followed, for the sake of clarity and for safety, for one of the Irish resident directors to be chair for that purpose. And then again, going back to what we were saying before, taking it that the directors might all be individually located, the meeting would be deemed to be located where the chair was, and so that would go some way to showing that they're having the meeting held in Ireland.
Thanks, Nick. So I think we've time for 2 more questions. Apologies, somebody has just started cutting down the hedge outside my window, so I'm finding it a little bit difficult to hear, but hopefully you can all hear me. So one of the questions, and I'm happy to take this one, is it appropriate for the board oversight to be devolved to the Audit and Finance Subcommittee at this time, keeping the board informed throughout, or should regular formal meetings of the board take place throughout this period? I think in relation to that question, certainly certain aspects can continue to be developed or delegated to subcommittees and executives. But certainly the board needs to be very close to the trading and the financial position of a company throughout this period. So if everyday oversight has been delegated, whether to a committee or an executive, there should be regular reporting to the board, so that it is the one that can ultimately make the decision. So where the members of the committee are all board members, I guess to some extent they are. They're the ones that a board, when it delegates its authority, retains responsibility still for the performance of all of its duties. So obviously where the directors are the ones on the subcommittee, that certainly helps. However, it's not all of the board. So the board retains its liability regardless. So I guess in times particularly like this, where there are economic challenges, the board needs to be across everything and not delegating responsibility for decisions relating particularly to trading ability and solvency. There's a final question, and it's asking about the best and safest way to send files, and I'm assuming documents online for signing. So when there's is there a particular best practice process to be followed when exchanging signed documents electronically or virtually? Do you want to take that, Nick? I'm happy to either.
If you're happy to, yeah, that please do.
And I mean, in terms of virtual completion of contracts, it is something that does happen in large transactions when they're closing late at night. But I guess I suppose the practical advice is to make sure that what is being exchanged and signed is the final agreed version. And when signatures are affixed and returned, to make sure that they are actually attached to the agreed form of the document. And likewise when the counterparty is exchanging their signed pages. And agree the process in advance. So agree a series of steps so that both sides can get comfortable that the correct version is exchanged, that they're happy that the manner in which the signature is being affixed is correct, that if it needs to be signed as a deed, the correct steps are taken to allow that to happen. If a witness signature is needed, that the witness signature is affixed. So the best thing to do is to agree the process in advance and to rigorously follow that process. So that I think is our time is up. I know we committed to having you finished by 11:45. We really appreciate that so many people dialing in this morning or attending our webinar. It's certainly a new way for us to present information, and we hope it was useful for you. We also hope that all of you and all of your families stay well, and we also look forward to everyone getting to resume business as usual as soon as possible. So we will circulate a recording of this webinar, the slides, and a copy of the survey, and if you could respond to the survey, that would be wonderful. So thank you all again, and we look forward to you joining us at a webinar very soon. Thank you.
Thank you.